Good afternoon, everyone. My name's Matthew Wanford. I'm a partner in Dentons' Ottawa office, and I specialize in technology and tech contracting, and I sit at the intersection of all of the presentations you've heard today, helping to document and contract for lots of the issues, lots of the risks that have been identified to you. So hopefully we can get through this presentation and get to some good questions, because I'm sure you've all seen some of the issues involved in the contracting process. And I'm joined with my colleague Joel, who I'll let introduce himself.
Hi, my name is Joel Bock. I'm a partner in our New York, New Jersey offices. And my background is patent law. I do trademark law, and I am the co-chair of our tech transfer department in the U.S. Venture Technology Group. And we will deal with some questions about and issues regarding technology transactions, contracting. You've heard a lot of interesting summaries on issues with the various different groups that have spoken today. And we're going to follow on that and discuss in a little more detail.
Thanks, Joel. So just a brief overview of what we're going to talk about in the presentation today. We'll just briefly touch on Canadian legislation or lack thereof, and some of the guidelines that I'm seeing some of the clients applying. Joel will briefly touch on the same. And then we're going to talk about one approach to AI contracting. In this particular case, we'll call off the ISED voluntary code, as mentioned by Chantal. As we've seen and heard from the team, there are lots of different frameworks you can use. We're going to try and drill it down to some practical examples of deals and contracts we've worked on, and try and tie it back to how, in practice, some of these frameworks are being implemented. So we'll talk about an assessment process, how we're seeing that assessment play out, how clients are doing assessments of data outside of the privacy impact analysis, which we've just heard from the privacy team on. Ultimately, a risk assessment that results from those initial assessments. And fundamentally, how does that represent itself in a contract? Like, what are we actually seeing on paper? And how are clients and service providers documenting the output of that risk analysis in the paper? Finally, we'll talk about developing the agreement, and then some of the pitfalls that you need to be aware of in risk management. So just starting with a brief overview on Canada. As we've heard from Chantal, Ada died on the order books, so we kind of have an absence of a legal framework to operate in with a specific AI context. However, as the privacy team have just said, there's a wealth of privacy legislation to take into account. There's also other pieces of legislation that can apply to the specific context of the AI. And this is the difficulty that we have to deal with, and this comes into the initial assessment of the AI solution. So for instance, the Consumer Protection Act could apply. Equally, the Bank Act, Canadian Human Rights Act applies to federal institutions. The Criminal Code could apply. Equally, if there's a consumer product and that product also uses AI, that legislation can also have an impact. Now, from an industry standard perspective, there are lots of clients here represented. You all have industry bodies which are pushing out their own guidance. Particularly in the bank context, we're seeing lots of that guidance coming through, and so you need to take that into account when building and developing the contracts around AI. Joel?
So in the U.S., Peter had spoken to this earlier, there's currently no comprehensive federal AI legislation, although the goal is to promote development of the technology, and in the U.S., it's to make the U.S. a leader in AI. So the Trump administration is trying to defocus on regulation and focus on more innovation. Currently, as Peter mentioned, there are a bunch of states that have implemented some legislation, California, Colorado, to name a couple. Other than that, there are a lot of proposed legislation, but there is potential for moratorium for 10 years. So there's this kind of a back-off approach, hands-off approach, just to help the industry develop AI and grow the AI technology sector.
Thanks, Joel. So in terms of AI and contracting, we've heard a lot about frameworks. We've heard about NIST, the ISO framework. We've also heard from the survey results that not every client or adopter of AI solutions is actually following those frameworks, which are inevitably quite detailed. In what we'll talk about today, we'll go over a risk assessment that you can perform with the intent of understanding the impact of that AI, and then fundamentally building that into the contract in line with whatever governance framework you have. Now, from an initial start point, it's obviously important to understand what is the actual AI solution that you're procuring. And I typically work on the buy side, for federally regulated institutions and other large national, international corporations. Even though a lot of those institutions are going through their own risk assessments, and I may be the recipient of their summaries when I start the contracting process, it's still incumbent on me as a lawyer to ask those open first principle questions, like what is it that is being procured? Who is the provider? How will that AI solution be used in the organization? Where is that AI solution being used? Is it solely in Canada? Is that occurring in another jurisdiction? These basic questions will inevitably get you in the right place, and they can be read in conjunction with a privacy impact assessment if you have one. That's obviously a best practice, and we don't always have access to that level of information. So always start with those who, what, why, when questions in respect to the AI solution. Now, what we heard from Peter earlier is these AI solutions are becoming more and more complicated, particularly with agentic AI. So what do you do as a lawyer confronted with these highly complicated back-end solutions? Asking those first principle questions will assist with that. Ultimately, in my case, I'm quite often asked to document what is behind the scenes. How is that AI solution constructed? Is there a subcontractor or a series of subcontractors or providers behind your main service provider? And how does that chain of subcontractors work together? And how does that AI solution work with other agent tools or agent models which may be directing data into your solution? And fundamentally, where is that environment? Where is all of this occurring? Is that happening in a dedicated, closed-off, logically segregated ecosystem, or is that publicly accessible in some way? So you have to start with these initial questions. Turning it to Joel.
And as a vendor, I do a lot of work with vendors. As a vendor, it behooves you to have some of those answers ready for the customer, right? Because obviously they're going to ask the questions, they're going to need to know that information. So as a vendor, if you could prepare that information, know who your customer is, know how they're going to be using your technology, it would be very helpful to help speed the sales process. From the perspective of assessing the data, there are certain fundamental questions, like what is the data? What will the data be used for, right? Will it be hosted, stored, transmitted, modified? Will it be viewed or otherwise accessed? Who's going to have access to it? Other questions that are important are ownership, right? Who owns the data? What data is being used? Is it your own data? Is it third-party data? Who's going to get access to the data? Is it your customer data? Right, and all those need to be asked and questioned, because depending on what those answers are, you may have the rights to that data, you may have to obtain rights to use that data, and you may have questions about who's going to have access to that data later on. And each one may have different individual treatment paradigms. As far as entitlement to the process, do you have the rights to upload the data, right? And so if you have certain customers, for example, you're a medical institution, you're going to have to get waivers from the patients to upload that data. What can you do with that data? Can you transmit it to someone else? There are all kinds of HIPAA guidelines. So it's not just AI questions, but there are other laws that come into effect that will determine what you can do with that data or how you have to deal with that data. There's also sensitivity, with, let's say, financial information, personal information, other types of information that you have to have the rights to transmit, to modify, to process. There are questions of location. Matt, you have some questions we were discussing about, where is that data going, right? Do you want to mention something about that?
So obviously, in the context of data locations, obviously a key question to answer. Different laws can apply in different jurisdictions, and as you heard from Kirsten, there's a higher degree of sensitivity from a Quebec location, and that may play into how you contract for or test that AI solution in the early days. So you've done your initial assessment on the AI solution. You may be doing that in conjunction with a broader team within your organization, involving security professionals, the business team itself, and other internal subject matter experts. As Joel's covered, you've assessed the data, you've liaised with the privacy team. This is all in an ideal world. You then need to do a risk assessment and to understand the risk impact of what it is, the AI solution in conjunction with the data, and what is the fundamental impact to the organization, and how do you effectively rate that overall solution? Is there a potential for reputational damage or harm to the organization? And so some of the key questions, I listed some of the old ones here under ADA. Equally, those questions are listed in the voluntary code. You need to answer these key questions to fundamentally assess what is the risk of this solution. How you approach or answer that question will ultimately influence the contract itself, how it's treated, how you approach the liability provisions, how potentially you may be drafting the representations and warranties in the agreement, with the ultimate goal of appropriately allocating risk as between you and the service provider. Now, inevitably, if you're on the buy side, you're going to receive some pushback from the service provider, and in some cases, you may not be able to satisfy your own risk levels when you receive some of that pushback. So effectively, what you're doing here is establishing a base case against which you're testing that negotiation and whether you as an organization can accept that level of risk or not. So just briefly turning to the voluntary code and some of the key questions, and we're still at the evaluation stage here. These are some of the topics that we would go through when trying to answer the questions. Accountability. Does the AI provider understand its role? And has the AI provider implemented its own risk management systems? Now, we've been directed to look at NIST, look at the ISO standards. The internal risk assessment process of a service provider may be different to yours as an organization if you are procuring an AI solution. So you need to understand, does the service provider's own risk management framework and the way they adopt it, if they have one at all, does that align with your own risk management standards? Equally, from a safety perspective, are there mitigations in place to ensure that there is an appropriate deployment of that AI solution? Has it been appropriately tested? Are there appropriate security controls in place? And how do those get represented fundamentally in the contract? Equally, from a transparency perspective, we've heard Under the Quebec legislation, there's an obligation to document whether an AI solution is being used or not, so the consumer or user of that AI application knows that they're engaging with an AI tool. You may also run into similar transparency obligations under different jurisdictions. And then fundamentally, there is a need to have human oversight in respect to the AI solution. Can it be switched off? Are you receiving appropriate reporting? Is the service provider capable of giving you the necessary information to enable you to perform that human oversight function? Just briefly touching on extraterritorial impact, if you are a Canadian service provider, you're selling into a different jurisdiction, you need to be aware of that additional laws in other jurisdictions can apply. One of the classic jurisdictions where there is AI law right now is the European Economic Area. You know, the minute you touch Europe, much as with the case of the GDPR, then you are going to be subject to and need to take into account European legislation. We're lucky at Dentons, we can pick the phone up to our colleagues in the UK and in our European offices to get that level of assistance. Equally, I have Canadian clients, one right now that's selling to a California client. I can pick the phone up to Peter and get some answers to those questions and deal with some of the AI-provided requests that we're getting from additional jurisdictions. In the California example, we're being asked to include a kill switch in the agreement, essentially a right to terminate if the regulator turns around and says that we have to terminate that AI arrangement. Equally, under California, there's a transparency provision. So one part of your initial assessment is to understand the extraterritorial impact of that AI solution, both in how you're using it and how you intend to use it going forward. And in the materials, you'll get a broader set of slides than this, where I've broken down actually into a detailed set of questions. So no need to copy this slide.
Okay, so when we're talking about developing an agreement based on the assessment and risk, which we just discussed, there are certain factors you have to consider. One is accountability. We have to determine whether the AI solution complies with internal policies. Obviously, that's the most important factor, right? Make sure that the company's policies match what your AI solution is providing. And are there any new policies that are required when you're developing this type of solution? There may be certain policies in place that were fine for a human interaction type of system, but when it's an automated system, like Matt mentioned, if you have a kill switch, you're going to have to put new policies in. Who's responsible for that? Who has to have that oversight? Is there training required? Obviously, if there's a new type of system in place, you're going to have to train your employees, train management on dealing with those issues. And is the provider going to provide that training or assist in that training? Because obviously they know the solution best. They're the ones who developed it. They can help in that training. So making sure that you have the right staff and the right people involved in that training process. Is there going to be some audit provision, right? Are you going to be able to audit it internally, audit it externally? You're going to have independent auditors. Are there certain provisions? Can you audit the vendor, right? It may be important to audit the vendor because as a vendor develops a solution, there may be changes made to the solution that may contradict some of the internal policies you have. So you need to have that process in place to make sure that you're vetting the system constantly, that you're constantly updating it and maintaining oversight on what's going on. Are there multiple lines of defense? If, for example, there is a problem with the solution, how are you dealing with that, right? Do you have policies in place? Do you have risk mitigation techniques in place? Do you have contractual provisions in place that will help you? Sometimes as far as accountability, if you have a vendor that's a small company, they may not be able to withstand a challenge to their product, right? If somebody sues them, they may go out of business. So you have to have procedures in place, contractual provisions in place, potentially that provide insurance coverage so that if they can't cover the damages or the risk, you have some sort of insurance policy that does. You may want to have a backup policy internally to cover that risk in case the damages extend beyond what's in their policy. So these are things that you have to think about. As far as safety, again, you have to have a comprehensive assessment as to how this solution is going to be used, what the potential risks are, what the potential damages could be if there's a problem. And those are things we have to consider. Also, what about inappropriate use? You have to think about your customers. Can somebody use it inappropriately? How do you deal with that? Are there contractual provisions with your customers that deal with them using it improperly? Or with the vendor, if the vendor has some sort of backdoor into the system where somebody could access it and do some damage, you have to think about all these issues. As far as fairness and equity, that's the last point I want to touch on that slide. Again, you want to know how it's going to affect your customers, right? Is it fair? Is it equitable? Do you have to deal with privacy issues, which the prior group discussed?
So human oversight is, obviously we've touched on it briefly, is an important one to consider. Now, one example I've experienced is with a biometric solution where an individual's face was being scanned in conjunction with their identification, such as a driver's license or a passport. This tool leveraged AI in the back end. Now, in that situation, due to the training of that particular AI solution, the way it worked, there were concerns around potential discrimination, i.e. rejection of those individuals from having access to the particular service because of the potential for bias discrimination in the training set creeping into the responses given by the tool. In that case, in conjunction with the employment team providing human rights advice, the privacy team, the determination following diligence done on the service provider was to understand what testing had they done to understand how accurate their tool was at identifying bias, and was that at an acceptable threshold for my client. As part of that, you need to have appropriate reporting. You need to understand, is that tool, the AI solution, operating at the required level? So in that case, we had weekly or more frequent in the early days of the solution reporting, so we could understand whether targets were being met, and so that bias was not creeping to the solution. Equally, and I think we've heard this mentioned earlier in the day, if somebody needs the ability, a consumer, a user needs the ability to effectively contact the client if they have been rejected, to try and understand, why has this happened, and is there another mechanism by which they can have their identity validated so they can get access to the solution. That's a perfect example of human oversight being built into the solution, and we're in conjunction with reporting and giving the user an alternative mechanism in which to access that particular service. Validity and robustness is a critical one, and we could spend an entire another hour talking about security and how security controls can apply to an individual AI solution. I spend a lot of my time talking about complex systems and their implementation. Security is a key conversation I have on a regular basis. And I would expect, when I'm dealing with a high-impact, high-risk AI solution, for there to be a dedicated security schedule. In an ideal world, the service provider would be offering a SOC 2 Type 2 security controls independent audit. Appreciate that's not always available, but that is the best practice standard that you would look for. Equally, compliance with an ISO standard of some form or another. But equally, your security team, or if you're on the buy side, should be having detailed and very specific discussions with the service provider about how the security controls apply to that AI solution. And I use the word solution deliberately, because quite often the AI model is interacting with databases and other agentic AI tools or oracles.
You also may want to have a limited deployment, right? Or an internal deployment for a test period to see how it affects the customers, what kind of problems there could be to weed out all the issues. And work closely with the vendor, obviously, to make sure that they're kind of involved in that process to make sure that if they need to tweak the code, they can do that before you do the full deployment.
So we spent a lot of time talking about the what and how it all works together. I think what our main point we're trying to convey there is you need to spend a lot of time up front trying to understand what it is you're actually buying. That time spent up front will actually help you by the time you get to this stage, which is documenting what we've been talking about in the contract. And this is a way of tying it all together, and we could spend several hours talking about these particular slides. But key points that I would point out for an operational or structural question is sometimes if you aren't getting the right answers to those risk questions, maybe, as Joel mentioned, a good idea to narrow the solution and actually what you're buying. There's been some circumstances where my clients decided not to buy the full suite of a particular solution and just decide to buy one small piece of it, test it in a smaller scenario, and structurally control how it's being adopted and used. Equally, if you're not comfortable with it ingesting or using all the data sets, you could try it with a sample data set or a smaller subset of data. And in that way, you can manage risk before you decide to take further steps with that specific service provider. Testing is a very key stage in all of this. Having milestones in your contract, if you're going through an implementation with stage testing, one of the key principles that is in the NIST framework is test, evaluate, verify, and validate. Testing is a fundamental part of all these solutions, and you should be building that into your implementation. And to Chantal's point about continuous improvement, testing those standards on a go-forward basis.
From a legal perspective, obviously, standard contract terms are things that form the basis of the contract. Obviously, they're going to need to be customized for certain situations. So your representations and warranties, those are critical because you want to make sure that they're tailored to the specific type of implementation that you're doing, the product that you're working with, the potential risks that are out there. So those are things you have to look at very carefully. That's what we spend a lot of time on, developing the reps and warranties so that it really addresses the issues, particularly if your indemnification provision covers breaches of reps and warranties. So you want to be able to cover any of the breaches that are of major concern. And so if you put those in the reps and warranties, your indemnification will cover you. You want to have to deal with risk allocation. If you're dealing with a big vendor, a vendor that has a standardized product, sometimes it's hard to shift risk. But oftentimes, if you're doing a customization of that, or if you're moving that behind your firewall, it's not going to be a publicly facing product, that's where you have more room to negotiate with the vendor. Limitations of liability. Obviously, there are carve-outs. Sometimes you want to have high levels, but sometimes you could cover that with insurance coverage. But you want to make sure that the terms are very clear, that there's no ambiguity, because when it comes down to enforcing a contract, the more ambiguity, the bigger risk. There are certain areas where there may be absolute prohibitions on use of customer data in the medical context, in other contexts. So you also want to be careful, again, how that data is being used. And I know a couple of the earlier panels mentioned, what do you do with data? Anonymization, de-identification, aggregation of data. If the vendor wants to use that data, how are they getting access to it, and what are they getting access to? And that's very important. Those are important questions to ask. And then as far as service levels with termination triggers, you want the vendor to be responsible and responsive. So you want to have strict service levels and certain penalties if they don't step up to the plate and do what they're supposed to do.
Now, all of this really needs to sit within a governance framework. Certainly, there's an obligation, should be obligations in that contract for continuous oversight. That can mean the establishment of committees that meet on a regular basis and test that the AI solution is actually performing in the way it should. Now, I do have a couple of slides here regarding the LLM context. We're running out of time, so I'll skip over them. But and Bob and the content ownership team did touch on some of the risks to bear in mind. I think most of the solutions I work on do not use public models. But just one word of watch out, and this was mentioned in one of the other terms, is if you do not want us to use your content to train our models, you can opt out by following the instructions. So in no circumstance really should you be using publicly available LLMs. And certainly none of my clients in the regulated space are doing anything like that. So just a final watch out here, when this comes from OSFI, which is the bank regulator here in Canada. Oversight must be agile, vigilant, and enterprise-wide. So back to that governance question, this isn't just a contract thing. This is an entire organization thing. There needs to be regular assessment risks across the AI lifecycle and contingency plans for explainability and control gaps. Like, I think that's really good advice, and people should take that away. So I think
So just to summarize and recap, it's very important to know the vendor and know the product that you're dealing with. Assess the risk, assess the data, and make sure your contract deals with those issues and addresses all those points so that you can protect your company and protect your customers. Thank you all. And I think at this point there's going to be a short break.
Okay, well, actually, just
After
a moment
questions.
for a. you're not done yet, but so yes, we have one question from online which I would like to take, and this touches on insurance, and I know, Joel, you briefly mentioned insurance, but during the olden days, there used to, in commercial contracting, be more requirements for cyber security insurance from the vendor when cyber insurance wasn't so prohibitively expensive as well as restricted. I think that those have become less common, but I'd be interested in what you have to say. Is there any, as far as you know, insurance product that speaks to these AI-specific risks? Is there a scope to develop such a product? And if so, would there be a potential insurance solution in commercial contracting to mitigate some of the risks that you've talked about?
Great question. I'm not aware of a specific AI policy yet. Typically, my clients, particularly on the federally regulated side and large institutions, have insurance brokerage advisories, and typically that results in a very large insurance clause which covers things like network security and cyber liability, pretty much as standard, where you're dealing with a large outsourcing or contractual arrangement with some fairly high thresholds in the millions of dollars. So I'm definitely seeing that, and it's a key question to ask, particularly if you're dealing with a small service provider, and that's a fundamental question they should be asking themselves, whether they have that insurance.
Yeah, I'm not sure if there are exclusions for AI software in standard policies. I would assume that if there aren't yet, there will be. So there will have to be specific AI policies, just like cybersecurity policies. Eventually, because of the risk involved with AI.
Yeah, and if it evolves that way, maybe those policies become a barrier to entry for smaller providers who may not be able to secure the insurance coverage that they need. Okay, all right, well, thank you very much. We are going to take a short break. During the break, you'll experience another immersive show. This is an ode to Graffiti Alley and Toronto's street art scene reimagined through the lens of AI. So there's an iconic stretch of Rush Lane hidden behind Queen Street West, which began as outlaw expression with graffiti scrawled on brick walls. And over time, it evolved into a celebrated showcase of creativity, community voice, and cultural identity. So please marvel at the creative power of AI, but please also be back in 20 minutes for our final presentations of the day. So thank you very, very much to Joel and Matt for their presentation.